SB 1718 is a new immigration bill specifically designed to cut down on the employment of individuals that are not authorized to work in the United States. It does this by specifically imposing obligations on private employers with 25 or more employees. Among other things, this law is going to require private employers with 25 or more employees to use the federal E-Verify system to verify a new employee's employment eligibility. Before, this verification was optional. Folks may have filled out these I-9s. Now, you're going to have to check and E-Verify. If an employer violates this law or hires an unauthorized worker, the DEO is authorized to impose a ton of penalties, such as the repayment of any kind of economic development incentive, probation with a quarterly reporting requirement, also revocation, suspension, termination of business licenses in some cases, and hefty fines. For example, if the DEO finds that an employer failed to use this e-verification system 3 or more times in any 24-month period, it can fine the employer $1,000 per day from the date that they didn't e-verify, on top of all of these suspensions and licenses, until the employer provides proof of compliance. Employers, you're going to need to have a good system in place to comply, and you can speak with a Florida employment attorney about how this specifically impacts you. Employees, especially those not eligible to work in the United States, guys, this is probably going to make finding employment much more difficult in the state of Florida.